So the case that I'm deciding to review is certain Iranian assets, and it began on June 14, 2016. And when we look at the background of this case, it really started with something that happened in the United States, which is the other principal actor in this case. So in Bank Markazi vs. Peterson, it was a domestic Supreme Court case inside the United States. And basically, what happened is. In this 1983 terrorist bombing, the United States intelligence services branded that Iran's proxy militia group Hezbollah was responsible. So, as a response, Iran was also responsible. Under FISA, which is the United States congressional law governing state immunity, Iran actually lost its state immunity because FISA has a terrorist exemption that takes away state immunity for terrorist states. And what happened is the United States tried to go to the ICJ to have Iran pay for the damages in the 1983 terrorist attacks. Iran refused, and it didn't really get anywhere. But in 2002, in the late 2000s, about $2 billion worth of assets was discovered, and $2 billion worth of Iranian assets were discovered in the United States. This, with the terrorist exemption of FISA and the Terrorist Risk Assurance Act, plaintiffs across the state were allowed to seek litigation against against Iran, and essentially take Iran to court in domestic U.S. courts. And this is exactly what happened with the Iranian Central Bank, who owned those $2 billion worth of assets that were discovered, which were frozen under an Obama executive order. And then from then on, we start to see that the playing field starts to change because Iran suddenly responds to its national bank, going into being forced under U.S. State enforcement, and then the U.S. also trying to seek litigation, its citizens trying to seek litigation for against terrorist bombing that happened on them. So that's personal harm and damage. And so then we start to see the mix of legal mechanisms. Iran relies on customary international law, while the U.S. is relying on FISA and its internal policies. And so what we start to see is finally Iran takes, to protect its national bank, as a maneuver, it takes the U.S. to the ICJ. Iran has pulled out of its compulsory consent, and so it had to basically prove the court's jurisdiction, and it did so by referring to this bilateral treaty in 1955 that Iran and U.S. signed when relations were good between these two states. And basically, in this treaty, it had exemptions that, under Iran's interpretation, meant that the national bank, especially Article Number 4, said that the national bank is protected. And so that's where we start to see the differences. And so that's basically the Iranian position, that it violated this bilateral treaty they had and the provision inside of it. But then they also went further and said that there's a violation of customary international law of sovereign immunity and the 2004 UN Convention on State Immunity, both of which Iran has ratified, and then the customary international law, which it respects. So going forward, you start to see the side of Iranian legal mechanisms. And then now, when we look at the U.S. response, you see that the U.S. actually challenges the court jurisdiction, says that it doesn't really have jurisdiction to hear claims of sovereign immunity, that the United States has its own policies, it has its own congressional laws, so it's not under the jurisdiction of the court to hear that. Also, it challenges the wording and interpretation of Iran's treaties. The treaty Article 4 mentions that there's nationals or companies that cannot be placed under the enforcement of the courts of the other party in the treaty. However, the U.S. challenges that nationals and companies do not constitute as a foreign as part of the foreign central bank of Iran. So the implications of this going forward are we start to see that there are multiple multilateral overlapping legal mechanisms when it comes to state immunity. We start to see that on one side of it, there's a huge part where you have the UN Convention, and then you also have customary international law, and a lot of states are going in the direction of following those legal mechanisms. But on the other hand, you have the US and FISA, where it has its own separate clauses, and you see how these different interpretations of state immunity could clash in the international court. The other big implication is the idea of sovereign immunity of central banks. Before it was a lot easier to distinguish what is a private act, what is a non-private act, and then further to that, now what is a commercial act, what is a non-commercial act, and all